thank you so much for having me here. Thank you to Professor Bentley, who I met only last month, I believe, at UC Berkeley in California, attending a conference. So I appreciate being amongst you all here. I'm going to talk a little bit about social media and trademark and copyright implications, and kind of how these issues are being dealt with in California. A lot of the terms and conditions that go along with it will be covered. I don't expect to speak more than 20 to 30 minutes, and then if you have any questions, feel free to ask. But just by way of a brief introduction, I'm a lawyer in California. I have a practice which is broader than what I'm going to be talking about, but this is an area of my research at Maastricht University where I'm doing my PhD, sort of in a more preliminary stage, but hoping to complete that as soon as I can. Essentially, the research I have or am conducting is about towards an improved legal framework for trademarks and copyright in social media. I'll talk very briefly about mobile apps, but it's mostly going to be based on social media. So let's just get quickly started here. Based on recent research, these are the most popular, I would presume, social media companies out there, and their locations, as you can tell, our head offices at least are in California, some in the Bay Area, a lot of them in the Silicon Valley. So as it stands now, you're all aware that the domain name disputes have a formal mechanism which can be resolved in the UDRP, but for social media it's quite different. Especially in California, the avenues that we have are quite limited when somebody takes your username or a username that you have put into commerce, you are using, or that you have registered with the USPTO, the Patent and Trademarks Office. So I'm going to talk briefly about what each of these companies do or can do, will do, with respect to trademark disputes, and then talk about copyrights in the same way. So these are some of the issues that present themselves, and technology is ever increasing, and that makes it more difficult for research. And I was speaking to Yin earlier, and we were discussing how the changes in technology just kind of mess up the research that we're doing, because it just creates a new wave and changes your direction that you think or that you're going into. So usernames are different from, as you all know, from a domain name. And a domain name, Coca-Cola.com or whatever the case may be, it can be registered. There's a formal dispute process. But what about usernames? And they're so different amongst the social media. On Facebook, you'll have a subdomain /Coca-Cola or whatever the trademark name is. On Twitter, you'll have the hashtag and you'll have a username. So every social media company has a different way, an account. It might be an account, it might be a subdomain, but it's a different beast from a domain name altogether. Then you have the impersonation issues, and it's much wider because of social media than we traditionally have in physical trademark or in marketing or advertising. It's a much wider domain that social media has brought about. Dilution, as you know, and then linking and framing when you link to other sites. That is also another issue. On the copyright side of things that relate to social media, it's just so easy to send out, copyrighted photos or content. It's just so easy to happen, and it happens on a much broader level. In the U.S., as you know, you need to usually register your copyright before you can sue on a practical level. So that becomes nearly impossible in most cases. And in social media, we're generating content all the time. So do we go register everything, before we can sue? So in social media, the law as it stands now is impractical, and that's kind of the areas that I'm looking into. Fair use, as you know, has similar to traditional copyright issues as it is in social media. Takedown is a very important concept in social media. On YouTube, especially, you'll find, having to police your copyright, having to police your trademark all the time. You need a mechanism in order to complain, and that's very important for this to be effective. Otherwise, we're going to need specific legislation to address those issues. There's much greater use or misuse, I should say, in social media of copyright. It's much easier to misuse than it has been traditionally. This has not been contemplated by the law in the US, at least, and to a large extent here as well. Not having been contemplated in the law is not addressing those issues. So what has happened is the social media companies have had to take on their own mechanisms, and in the form of self-regulation, as we see it prevalent here in the advertising or marketing law or marketing industry. We see a lot of self-regulation, and that informs the social media law as well in the United States. So the self-regulation that we see is what I'm going to be discussing in just a moment. Before I do that, this is a brief snapshot of some of the key legislation in the U.S., which I'm sure a lot of you are familiar with, but the key is the Lanham Trademark Act, which is codified in 15 United States Code. And that deals with trademark infringement, trademark dilution, and false advertising. So that's the key piece of legislation. And trying to apply that to the social media setting is very difficult. Although we have to borrow from these concepts, we have to use these concepts generally if we're going to rely in a court of law on addressing some of these trademark issues that come up in social media. That's the backbone. That is the basis still. However, the alternative is that self-regulation that I was discussing, and I will be discussing more. Then in 95, the Federal Trademark Dilution Act, which may not be a direct violation, but something that dilutes, as you all know. These are common concepts here and in the U.S. Then a special act, the Anti-Cyber-Squatting Consumer Protection Act, came about, where if somebody takes your domain name, you can sue them. That can take time, that costs a lot of money. Is that an appropriate mechanism? Is that going to work for social media? If somebody takes your username, or a username that relates to your trademark, which is either a trademark that is registered with the Patent and Trademark Office, or one that is being used in commerce. Either which way, there's certain protection. But going to court, spending a year, 2 years, however long it takes, all the money in legal fees, things of that nature, is that really practical in a social media setting? Because in a social media setting, a lot of things are happening. They're happening quicker, and the impact of what's happening is also larger. And then Trademark Dilution Revision Act clarified some of the earlier dilution issues. There's a case law on those. We all are familiar with the UDRP, which deals with domain names, but how is that applicable in the social media context? It's not directly applicable in that sense. There's other regulations, and then there's the USPTO. So this is a snapshot of some of the key legislation and laws or regulation in the US, mostly on a federal level. And of course, there's California-specific law, which kind of supplements, but is not as important as what's here. So what are the issues? Social media usernames or account names or other types of names can create confusion. And it's very difficult if a company doesn't go out and say, okay, there's this new social media that's out there. Let's go register our trademark on there. Let's go register all of our possible combinations of trademarks as quickly as possible. But if you don't get to it in time, then somebody else might get to it and ask you for a large sum of money in order to release that to you, sort of like the domain name cyber squatting. Plus, there's an international use of social media. There might be a St. Peter's school here. There might be a St. Peter's school in India. Now it's all coming to the forefront because of social media and of course the internet. But what is the jurisdiction that, if there's a dispute, what is the jurisdiction going to be? And I'll show you snippets from the terms of use of each of the social media briefly to tell you about jurisdiction. And then in the Lanham Act, there's a use in commerce requirement. And social media does not necessarily lend itself to use in commerce all the time. Sometimes we're engaging in social media for personal use, and we are using potentially trademark names. So in that sense, it may not be recognized that this is a violation because there may not be use in commerce, which is a requirement. And unless you're making money from it, or unless you're meeting some other lower standard of use in commerce, you may not have that protection. And that's another issue in social media that can be problematic. So let's take a look at each of the 4 social media companies, and I'll just briefly go through this with you. What does Facebook say? They can disable your account if you're a repeat infringer of IP rights. So if people are complaining about you and Facebook investigates and they say, that's legitimate. By the way, probably all of you have Facebook accounts. How many of you tend to read the terms and conditions? Not many people out there do. So what they're saying is, you're not going to get booted out by just infringing once. You have to be a repeat infringer before they're going to do anything about it. They use words like will disable your account when appropriate. So there's no clear guidance as to what they're going to do. It's when appropriate. It's when they determine something is wrong. So you have to pretty much provide your proof. Is it better than going to court? Probably is, because it's a much faster process where Facebook will investigate and decide what to do. And the terms of use here give them the authority to disable your account. Facebook says they have license rights to your IP content until you delete it. This is not the same as other social media companies who clearly say it's all yours. Nothing is ours, it's all yours. But Facebook says they have license rights to your IP content. Many people are not aware of this. You can report to Facebook any claims of violation, trademark or copyright. So if there's a trademark violation, there is a mechanism available where you can report that and you can get them to investigate and decide what's going to be done about that username, for example. They reserve the right to remove and or reclaim any username at any time for any reason. So there's some broad assistance to trademark holders, at least there. Right to remove or reclaim if we believe it is appropriate, such as when a trademark owner complains about a username that does not closely relate to a user's actual name. This is different from domain names, because if a trademark owner or a username owner has the same name as a more famous person, then they may not do anything about it. That person may just get to keep it. We don't know for sure because there haven't been a million cases or published information about what Facebook does, but there have been a few, and I'll go through those with you. So what does Twitter do? Twitter says, we're not responsible for your content, you retain the rights. So a little bit different from what Facebook says. So as you can see, there is a difference between each social media company. So the problem is, do we need consistency or uniformity? Do we need a law which applies everything uniformly with the same type of issue across the social media boards? If you don't have the right to submit content for such use, it may subject you to liability. Okay? We reserve the right at all times to remove or refuse to distribute any content on the services, suspend or terminate users, reclaim usernames without liability to you. Protect the rights, property, or safety of Twitter, its users, and the public. So they use some general statements as well. Broadly giving them some ability to do more than you might wish them as a user. Twitter respects IP rights of others, expects you to do the same. If there's any confusion, which is obviously the key base point to trademarks, they'll give you the chance to clear the confusion. They may release username to trademark holder, and I'll talk about a case that involves Twitter as well. Where there's clear intent to mislead, they're going to suspend your account. So, each company is different. Some go farther than others in the terms of use. For LinkedIn, when you sign up, you will not violate any rights of LinkedIn or a third party, including IP rights such as copyright or trademark. You can't upload, post, email, or transmit content that infringes on any of these IP rights. So their terms are much smaller, less clear, less detailed, as compared to Facebook and Twitter. Google Plus says we may suspend or stop providing our service to you if you don't comply with our terms. We may review content to determine if it violates our policies, but we're not going to go out and check. We're not going to be out there checking for violations. So they clearly say, please don't assume that we're out there checking. Because if they're out there checking, then according to US law, they may be looked upon to be required to continue checking. So they don't want to be in a position where they put themselves into this checking mode. So far, most of the companies have been safe from liability and are not required to go out to check and police. That's the trademark owner's problem. You can file an impersonation claim with Google+. So again, all 4 companies have mechanisms. Each of these have their own differing terms and conditions. Some do more, some do less. It's not uniform. So case on point is Coca-Cola. Somebody went out and registered on Facebook a Coca-Cola account, and over 1 million followers in 3 months. Now Coca-Cola says, oh my God, they've got our Facebook name. We need it. But what do? Do we want to look like the bad guy? This thing has 1 million followers already. What do we do? So they had to make a decision, and they ultimately came to a settlement, which is where most of these cases are going. Most of these cases are settling, social media, legal issues, and trademarks. They came to a settlement where they maintain certain control over the Facebook page. They don't generally own that Facebook page today, but they maintain a sufficient control under the settlement of that page. So there was initial confusion, complaint lodged. This is the result. They actually don't own fully that Facebook page even today. We wouldn't know it, but that's how it is. Louis Vuitton, California case, 32 million jury verdict on a judgment against the web hosting company. The web hosting company received numerous complaints, multiple takedown notices, did nothing about it. This is one of the few cases out there which gives liability to the web hosting companies. And then La Russa, a well-known baseball manager, currently managing the St. Louis Cardinals, sued an unknown party for registering his name on Twitter, making comments which he would not have generally made. And he claimed trademark infringement. He filed a claim with Twitter. Twitter did transfer the name to him. So a lot of different things happening on this front in trademarks, and it does depend on which social media outlet you're complaining to. There are differences amongst them. Okay. Any quick questions on trademark?
Yeah, sorry. Yeah. What was, in the Louis Vuitton case, what was the social media?
This one here, counterfeit products on hosted sites. What it was that they were selling stuff, and a lot of the stuff on the sites were counterfeit. And the web hosting company received the notices because I believe the websites were not able to be found.
Are you Is that social media, or is that just?
It's not. I believe that the sites themselves that were being hosted had relation to social media, or you get there through social media, but not entirely. Not entirely.
I have a
Yeah.
question with case one.
Yes.
So did Facebook get involved in trying to help
Yes.
this settlement?
Yes.
Oh.
It was done through this self mechanism, as opposed to through legislation, and as opposed through the courts.
But okay.
Yeah.
So Coca-Cola complained.
But
Yes.
three parties were involved now, was it? So there was Coca-Cola, Facebook, and the fan.
Yeah, I've seen cases which the social media company is not party to the issue, but they're complaining to them. And then Facebook is investigating and then deciding what's going to happen under the terms of use.
And that's what happened here.
That's what happened here.
So Facebook decided Coca-Cola would get to maintain certain control.
Ultimately, it came down to a settlement in this case.
Coca-Cola
Yeah.
decided.
Yeah. Well, the parties came to a settlement in that case. So there was no formal decision ultimately. And then as far as there's some new .com disclosures from the Federal Trade Commission, the FTC, relating to disclaimers. And you know how on mobile phones or in apps, there's not enough space to write all your disclaimers. And sometimes those disclaimers have to do with trademarks. For example, somebody using a similar name who wants to disclaim that we are not Coca-Cola, or we are not so-and-so, or we are not related to the U.S. government, or whatever the case may be. There's not enough space to do that. So there's new guidance now on how far you need to go in order to make disclaimers in mobile apps where there's less space to do so. And then in terms of the copyright angle, we're all familiar with the basic copyright law or legislation, but what are the issues with social media? It's so easy to repost without permission. It's so easy to get things and send them out or post them on various social media outlets. It's a new beast, as we all know. Same idea with the international use of social media. For example, if you go to facebook.com/Facebook UK and you go to terms, it will link you back to the general terms and conditions. And in there, you will see the jurisdiction to be California if you want to complain. So they talk about California and the Silicon Valley jurisdiction. There's no particular Silicon Valley jurisdiction. I think it's Santa Clara County jurisdiction where disputes are going to be held. So even if you're in another country, they may have specific jurisdiction, but from some of the ones that I visited from different countries, they link back to the California jurisdiction. So that becomes another issue. Plus, who is the one who took your account? Where are they located is another issue. So it's much more difficult than in the traditional sense of copyright. User-generated content, postings, videos on social media, copyright violations are pretty much gone viral on social media, generally speaking. So Facebook, they say if we are, you complain, we may remove the content, but after we remove it, we might, if we removed it by mistake, let us know, and then we will provide you an opportunity to appeal. So that's one of the companies who has sort of an appeal mechanism, and some of the others don't. Copyright does not protect names. That's all trademarks. That's general information. So you need to submit a claim of copyright infringement, and I believe they have an actual form to do so. So they formalize the process. I found that the copyright area is more formal than the trademark area, excepting for usernames under trademarks. That has a little bit of a formal process, but copyrights is more formal. So you may have a better chance if there's a copyright infringement, depending on the type of infringement. And but they warn you that copyright infringement is a serious matter involving legal process. So do it only if you know that you have the rights to that copyright. And then the DMCA, these complaints and notices that need to be given to Facebook must be compliant. And you need to send, there's a designated agent where you send the complaint to. That's Facebook. Twitter, we will respond to notices of alleged copyright infringement. So again, they're also doing the same thing. That comply with applicable law and properly provided to us. They can remove content alleged to be infringing without prior notice. Inappropriate circumstances, Twitter will also terminate a user's account if the user is determined to be a repeat infringer. So we saw that with Facebook as well. They will terminate if you are repeatedly infringing. LinkedIn, again, you promise not to violate any rights, terminating accounts who, again, repeat infringer. So they've some have borrowed from the others, I would imagine. They've borrowed some of the this self-regulation, so to speak, from the others. And finally, Google+, we respond to notices, again, terminate accounts of repeat infringers. So you'll notice, unlike in the trademark terms and conditions, when it comes to copyright, they're all saying the same thing. And they have more formal mechanisms than under trademark. But in Google+, you can also file a counter notice to reinstate removed content, like Facebook, as we saw earlier. They just call it something different, that's all. So some cases for copyright is a FlavaWorks versus Gunter. Last year, there was a MyVidster, which is a social media video website. Users upload links and embed videos. Need to correctly police site for infringement? That's the question. Does the creator or the site owner have to police the site for infringement? A concept we talked about earlier. Issuance of an injunction was improper in the lower court since individuals who bypass plaintiff's paywall to watch copyright videos are not copyright infringers, and thus defendant could not be contributory infringer. So what happened here was people were getting through or hacking their site to get to content which they should have paid for. And that's not truly a copyright infringement. It's a violation of some other laws. So as a result, the social media site should not be responsible from a copyright angle. That was one of the cases. Instagram, which is a Facebook company, they decided in December, just this December, that they're going to say something to the effect of, we're going to change our terms. That Instagram has the right to sell the user photos. Whatever photos you upload, now Instagram can sell them. That's the interpretation that users had when they changed their terms and conditions. A lot of people complained. In fact, there was a lawsuit as well by Funes, sued Instagram before the new terms took effect. So they gave 30 or 60 days before their new terms took effect. Before the new terms took effect, they got sued. And just recently, in February of this year, Instagram moved to, or asked the court to dismiss the lawsuit because the person could have, if they didn't like the new terms, which they need to comply with according to the old terms, saying that we can change our terms anytime. So if that's a valid contract, then the person could have disabled their account or canceled their account. So they don't have standing to sue, generally speaking, is what Instagram has alleged. So that's an ongoing matter, I believe.
Sorry, what
Yeah.
did they sue for?
The new terms and conditions should not be applicable to the user, and they're out of the bounds of the contract. And but generally speaking, if that's in the terms, that's in the terms. Then they can change it. But
retrospective?
yeah.
Or was it?
Oh, I don't believe it was retrospective. I'm not 100% sure, but I don't think they were going retrospective. They were allowing some time before those new terms go into effect. And then the third case, Morel, the U.S. District Court for the Southern District of New York, Twitter images. This is a Twitter case where during the Haiti earthquake, there were some pictures tweeted. Those pictures were used by AFP, and then you found those pictures all over the place, pictures that somebody had taken. So media outlets took pictures and used them directly after seeing them on Twitter. And the AFP, the media outlet, argued that once these pictures appeared on Twitter, they can freely use them as per, they were interpreting the terms of use to say that anyone can freely, not Twitter themselves, but anyone can freely use the pictures. And the court said no, retweeting might be okay, but more importantly, you cannot take them for commercial use. That would be a violation. So there have been only very few cases in the United States and in the Silicon Valley that relate to these terms of use issues and in social media, both trademark and copyright, but we're seeing more and more of them. And these are some of the issues that are coming up. And we have yet to see some more cases, some more authoritative and some more higher level precedential decisions on some of these issues. So it is still in the flux. And finally, as that research progressed, a new thing came out in the US, which is on a more mass level, I should say, not brand new, but this 3D printer has now come out where you can print something and it comes out in plastic. Whatever design you have, you can print it out and it comes out not on a paper but in a plastic, like a cup. You can print out a cup with a logo on it or a trademark on it. And so now that raises both trademark issues, obviously, because people can print out stuff with Coca-Cola symbol on it if they wanted to, so far as I know, and then copyright issues. Maybe the design that they're printing out, there could be a copyright on the blueprint. So overall, technology is raising new issues not contemplated by the law earlier, so there's gaps. Do we need law, or is the self-governance, the terms and conditions and the dispute mechanisms with the social media companies, is that enough? Is it going to work? Or do we need legislation like the UDRP to deal with those usernames and trademark and copyright issues? What kind of dispute resolution system should that be, or is it working? And do we need uniformity between all the companies? Or is it okay to let each handle it in the way they deem appropriate according to their own terms and conditions? Is it right for the law to impose uniformity on them if necessary? So those are some of the gaps that I'm looking into. Law is based on old concepts. Social media was not contemplated at the time when that was drafted. And new technology gives rise to novel IP law issues. So that's a little bit of what I had to say. Any other questions?